And the ninth issue was whether the court erred in failing to grant the appellant a new trial based on newly discovered evidence. And the first of the four things that were withheld was a note that a witness had claimed Mr. Elliott told him that Leroy said if Mr. Elliott got the police on him, he would be dead, indicating Mr. Elliott would be dead in a motive. Defense argued since their theory was Mr. Elliott could have committed the crime, that this was relevant and important. And the second was similar. It was a statement from an apartment manager who said that Mr. Elliott always had people over and that he thought they were taking his money, which would go to motive again, that these people could have been stealing from him, and that's what set him off. Third piece of evidence was the fact that an officer asked to check the state's witnesses for any convictions of false statements or dishonesty, and Mr. Elliott had a theft conviction that wasn't disclosed, and the state's argument I thought was interesting because they basically argued that he was so untrustworthy already because on cross-examination it was shown that he was a heavy drinker, possibly an alcoholic. I think it was.
This was the state's argument?
Yeah, the state's argument was that he was so unbelievable on the stand that they couldn't have made him any less credible by throwing out that he'd been convicted of theft.
That is hilarious.
Kind of true, though.
It is.
Well, I know, but for them to make that argument,
it's kind
that's
of a
pretty
unique
ballsy.
argument to argue that your star witness is the least credible person on the
And
stand.
again, a
Couldn't
question
make
I
him less
have here,
credible.
were there any constitutional cases cited or constitutional provisions
No.
cited in this issue?
The state, they also had another terrible argument that they argued the two above-mentioned statements were not exculpatory on their face. They only became exculpatory when taken in conjunction with the defense's theory. So.
Okay, well, how does that square with you have a duty to turn over evidence that's favorable to the defense?
Right. Well,
Supreme Court didn't seem to care very much.
Okay.